Breaking news, guys. Nigerian government to rule on IPOB leader Kanu's bail application on Monday. Kanu, who filed the bail application through his legal team, led by his lead counsel, Barrister Aloy Ejimakor, said that the motion on notice dated February 5th, 2024 was brought before the court pursuant to Section 6, 35 and 36, 5 in brackets, Constitution of the Federal Republic of Nigeria has amended Sections 158, 161 and 162, Administration of Criminal Justice Acts, and under the inherent jurisdiction of the court. Welcome back to Prospect Channel TV. Thank you for coming out here. If you're just joining us, please kindly subscribe to this channel and don't forget to give us a thumbs up. Thank you. Justice Binta Inyako of the Federal High Court, sitting in Abuja, will on Monday rule on the bail application filed before the court by the detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, on the terrorism charge filed against him by the Nigerian government. Kanu, who filed the bail application through his legal team, led by his lead counsel, Barrister Aloy Ejimakor, said that the motion on notice dated February 5th, 2024 was brought before the court pursuant to Section 6, 35 and 36, 5 in brackets, Constitution of the Federal Republic of Nigeria as amended, Sections 158, 161 and 162, Administration of Criminal Justice Act, and under the inherent jurisdiction of the court. Kanu prayed the court for an order admitting him to bail pending the determination of his trial on the case marked FHC/ABJ/CR/383/2024, remitted to the court by the Supreme Court, and for such further order or orders as this honorable court may deem fit to make in the circumstances. The IPOB leaders team said that Kanu relied on all the paragraphs of the affidavit, the exhibit, and the written address to urge the court to grant his prayers and to determine whether the applicant has placed sufficient facts and materials before the court deserving an order of this honorable court admitting the applicant to bail. Whether the applicant has placed sufficient facts and materials before the court deserving of an order of this honorable court admitting the applicant to bail. In this point of argument for the bail application, the legal team stated, "We will wish to make it clear from the onset that this written address is not about whether the applicant had trumped his previous bail or not, as such might be considered academic in view of the content of paragraph 17 of the affidavit and exhibit Mazi Nnamdi Kanu 3. It should therefore be understood that any portion of the affidavit and the exhibit speaking to the issue of the previous bail was adduced for the necessary purpose of presenting a fuller historical background of this case. However, in persuading your leadership to exercise sound judgment in favor of admitting the applicant to bail, we respectfully invite my lord to a disproportionate reading of the concurring judgment of Emmanuel Okomai Agim, JSC, particularly the pertinent part that was set out in applicant affidavit, pages 10 to 13 of the said concurring judgment as exhibited. In addition to the foregoing, it is also pertinent to note that in their concurring judgment on the issue of the previous bail, the order three learned justices spoke in the same vein as Justice Agim did. Despite this, we still made a considered judgment to adduce more relevant evidence, particularly exhibits Mazi Nnamdi Kanu 1 and Mazi Nnamdi Kanu 2, which are highly probative and thus capable of assisting this honorable court to make an independent determination on the issue and most probably reach the same conclusion reached by the learned justice of the Supreme Court. Turning now to the general guiding principles for granting of bail, we submit that the concept of bail as a fundamental factor in the criminal justice system is basically a constitutional right in Nigeria. This position, which is anchored on the provision of Section 35 of the 1999 Constitution of the Federal Republic of Nigeria, has been affirmed in a long list of cases. However, the decision to grant or deny bail, particularly the type of bail granted to an accused person pending trial, is gradually at the discretion of the other court. The said discretion which must be exercised judicially and judiciously depending on the peculiar circumstances of each case. This constitutional right stems from certain other rights, namely presumption of innocency until proven guilty. See Section 35, 1 in bracket of the 1999 Constitution of the Federal Republic of Nigeria, and the right to personal liberty. See Section 36, the 5 in bracket of the 1999 Constitution of the Federal Republic of Nigeria. Anyway, guys, these are Mazi Nnamdi Kanu's team asking the Federal High Court to grant Mazi Nnamdi Kanu bail and all that. Let's watch and see how this unfold on Monday next week. Kindly share your thoughts below the comment section. Please don't forget to subscribe to this channel. Share this video, let it go viral, so Nigerians can understand what is going on.